Can I get homestead exemption if I rent my property? Have you ever wondered if you can claim a homestead exemption on a property you rent? This is a common question, especially for those navigating the complexities of bankruptcy. Let's break it down together. The short answer is no, you cannot claim a homestead exemption on a property that you rent. The homestead exemption is specifically designed to protect the equity in a home that you own and occupy as your primary residence. If you are renting, you do not own the property, which means there is no home equity to protect. In the context of bankruptcy, the homestead exemption allows individuals to shield a certain amount of equity in their owned home from creditors. This exemption varies depending on where you live, but the key requirement is ownership of the property. For example, under federal bankruptcy exemptions, you must own the property to qualify for the homestead exemption. Rental properties are explicitly excluded from this protection. If you are renting your home, you do not have an ownership interest or equity in the property. Therefore, there is no asset to exempt under the homestead exemption rules. The exemption is meant to help individuals keep their primary residence by protecting the value they have built up in their owned home, which simply does not apply to renters. From a bankruptcy perspective, if you rent your residence, you cannot use the homestead exemption to protect any interest in that property. Instead, your bankruptcy exemptions would focus on other types of property and assets that you actually own. To summarize, the homestead exemption is only applicable to properties that you own, not those that you rent. Renters cannot claim this exemption because it is tied to ownership and the equity in a home. If you are facing bankruptcy and renting, it is essential to look into other exemptions that may apply to your situation. Understanding these rules can help you navigate your financial challenges more effectively.